Today, death penalty lawyers are a rare, though increasingly much-needed breed. In the incidence of capital cases, the U.S. Supreme Court has recognized what research has long shown. Jurors often make sentencing decisions prematurely, and they often base their decisions on their personal reactions to the defendant, their confusion about the rules of law, and their lack of understanding regarding their own role and responsibilities. In an effort to safeguard against jurors' unguided emotional responses when determining punishment for capital defendants, the court set forth a legal standard that requires defense teams in capital cases to conduct thorough investigations into the defendant's backgrounds. If the defendant is found guilty, the information derived from that investigation must then be presented as mitigating evidence during the penalty phase of the trial. The capital mitigation process comes to life when a legal defense team's social worker, using a life history model of investigation, assumes the role of mitigation specialist and, by capitalizing on social work theory and research, practice knowledge, and skills, yields vital information that, through objective presentation of fact, guides sentencing. Gold standard for mitigation practice is reliance on focused investigation and presentation of evidence about a defendant's life and character that is sufficient to compel jurors to consider a complexity of personal, social, and ecological issues in deciding attribution of responsibility that mitigate defendants' legal accountability in capital offenses. The established mitigation strategy that relies on social histories and life stories survives and thrives as a legal mandate and preferred approach in capital cases. Today, the Insider Exclusive presents one of America's most successful capital defense mitigation and consulting teams, CLS Mitigation and Consulting Services, in a special program entitled Building Capital Defense Teams. Featuring Cindy Short and the CLS Mitigation and Consulting Services team, who have successfully created capital defense teams to defend the innocent and the very guilty. They work hard to understand the lives of people who take the lives of others. Cindy and her team work in states where political will for executions is high and the commitment to public defender programs non-existent. They are deeply committed people who have chosen to make their mark on this world, and that is why Cindy Short has earned the highest respect from judges, juries, prosecutors, and lawyers alike as one of the best capital defense lawyers in America today. Hi, I'm Steve Murphy, and this is the Insider Exclusive, live from Kansas City, Missouri at the McAllister Law Firm and the CLS Mitigation and Consulting Services team. It is my great pleasure to introduce Cindy Short to the show. Welcome to the show.
Thank you.
This is a show we're talking about your CLS Mitigation Services, Consulting Services, where you mitigate capital defense cases. Mm-hmm. You can choose many types of law to practice, but this is an area that you particularly like. Why?
Yeah, you know, it's interesting because when people ask me that, other lawyers, I tell them that it really has been an unhealthy lifestyle choice.
Really?
Yes, because you are constantly involved with crisis and loss and death. So it is a very odd thing to choose to do for 16 years. But it is an important thing that we do. I love to learn about people. I love biography. I am constantly being challenged in terms of the facts of the cases, the individuals that I come into contact with, and I love the collaborative process of working with talented young and not so young attorneys who have decided to put their time into these really difficult cases.
Mm-hmm. I have a question though for you. You know, when we are talking about representing the damned, mm-hmm. Sometimes you're representing people who have been charged with heinous crimes, but they're innocent. Yeah. And sometimes you represent people who have clearly done the deed. What is your feeling? And obviously you have had some clients say to you, yes, I did it. Mm-hmm. What is you're instantly want to go into this biography mode about finding why would you have done such a thing, right?
Right.
I mean, that's a great human curiosity on your part. Is that one of the reasons why you do this work?
I think so. I think I am really very curious, and I have through the years, I don't know if it's my Catholic education, my devotion to service, really felt like we have an obligation to understand why these things happen and to really try to provide some answers so we don't repeat it over and over and over.
Give us an overview of CLS Mitigation and Consulting Services. What do you do?
This is a group that I began in 2003 in which we provide a very particularized service for attorneys, attorneys who are appointed to capital cases. The ABA guidelines and the Wiggins decision, which I know you're familiar with, both say that a team has to be formed in order to represent an individual charged with a capital crime. That team must include 2 attorneys who have experience in capital work and a mitigation specialist and an investigator. That is your core team. And so on that team, we provide the services of the mitigation specialist, which means that we are responsible for investigating the life of the accused from before his birth until the moment we go to trial.
And today, a lot of those cases are represented by public defenders. Do they have the funding to, are they mandated to get the funding to do this?
You know, as we go across the country, it's so different from jurisdiction to jurisdiction. Most capital cases are actually staffed by people who are in private practice, but who have come up on a particular list or have earned enough CLE credit or experience to be added to a list. So, for example, in Texas, they have lists that the judges can draw from of private attorneys who can be appointed to these capital cases. But these are men and women who have regular practices and do not spend their lives on capital cases. Many, many lawyers will only take one capital case in their career if they ever take one at all. Because, as I said at the beginning, it is not a healthy lifestyle choice.
Healthy meaning what? You are stressed out about the whole situation?
Yeah, I mean, you are, lawyers who do civil work very often will say to me, you know, Cindy, you do the real work. Because we're dealing with money and injuries that are very important. But, you know, at the end of the day, the law only deals with life and death in one way, and that is in these capital cases.
In these capital cases, do you sometimes have the feeling that you get too emotionally involved with a case rather than saying to yourself, I'm doing the best job I can do?
Well, I think in order to really do the best job you can do, particularly when you are charged with exploring and then being the voice for another human being, putting a face on that human being, you cannot do that unless you're willing to really emotionally commit to it.
Tell our audience how you develop the story of that person's life so a jury can understand exactly what took place, not only what took place, but what led up to the crime.
Well, you know, we look at every aspect of that life, and what we find is that very often we have to go back and explore the lives of the parents of our client to be able to understand how our client came to be how he or she is. And so we are genealogists. We have to look at medicine and how the health of the individual affects their choices. We have to look at their brains. We have to look at their relationships through life, starting at birth. We have to look at the relationships that come in education. So it is unending in terms of what we can be looking at to be able to understand. Many of our clients don't understand or have insight into how they ended up where they are. Many are too young to be able to really understand it.
Have you represented clients who come from privileged backgrounds?
No.
So there's no mitigation focused in on their crimes?
Well,
on their cases?
You know, so often in capital work we hear about the racial disparities of those who are charged with capital crimes, and that is a true statistic. But the number one, I believe, the number one criteria that is true across the entire scope of capital clients is that they are poor, period. Rich people do not get charged with capital crimes.
Interesting. Talk about restorative justice.
Well, restorative justice is a movement that I believe strongly in. The way in which our criminal justice system is set up as an adversarial system, we are really taught to make the world very black and white, to have enemies and to have opponents and to be warriors in that courtroom. In fact, for the people who are most affected by what's going on in the courtroom, that is the victim survivors,
Right.
the families of the accused, the families of the victims, the witnesses. For them, this is a very hostile environment, one that's very scary for them. And the more we can do to help people understand the process, to embrace what the needs are of the victim family members, for example, so that when people walk away, they not only feel like justice has been done, but they also feel like we, as part of the criminal justice system, haven't re-traumatized them or traumatized them in a whole new way. And so I really firmly believe that there are changes that we need to make, and they're going to be made incrementally by people like me and the people I work with, to reach out and embrace people from all parts of the case.
How do you do that with the victims' families?
We have, starting with the McVeigh case way back in the 90s, there was a woman who began something called defense-initiated victim outreach. And she came from the learning of restorative justice. And really she started to go out to those many, many, many victims during McVeigh's case and simply sit down with them and say, I have never met this Mr. McVeigh. I am not here to advocate his position. I am here because I want to understand your needs. I want to understand how we can make this process more humane for you. Right.
Your team members actually do that?
Yes. We have trained people on my staff in defense-initiated victim outreach, which is a intensive 40-hour course, followed by really pretty intensive mentoring by the leaders in the field.
We have with us today another lawyer from Shook Hardy Bacon, Bruce Tepekian, who is going to come on and talk a little bit about the case, one of the cases that you guys worked on, did a fabulous job, so let's bring him on right now. Great. It's my great pleasure to introduce Bruce Tepekian, a partner at the law firm of Shook, Hardy & Bacon. Welcome to the show.
Thank you. Nice to be here.
In a nutshell, what was Denny Wolf charged with?
He was charged with a double homicide of an elderly couple in, Camdenton, Missouri, which is down by Lake of the Ozarks. He went through his first trial and was found guilty and given the death penalty. The subsequent appeals, he was overturned for ineffective assistance of counsel.
Which was the public defender's office.
Which was the public defender's office, yes. We then were contacted after the public defender's office was, for lack of a better term, disqualified from representing Danny. We were contacted, Shook, because we could afford to be able to take on a case of that magnitude pro bono, and then we partnered with Cindy, who offered her time pro bono as well.
So that our audience understands that word that you mentioned, could afford. I've often read that an average murder trial costs at least $1 million to defend. Is that correct?
When you put attorney time in.
Yeah.
Because it's so labor intensive, isn't it? How long does it take? A couple years?
It took us a couple of years to go through. We went back, kind of started from afresh with the file. We went back, went through it, did a lot of depositions, a lot more discovery than was done the first time, a lot of feet on the ground. We also, you also have to hire experts to come in and testify on various issues, and we did that.
And to teach us.
And to teach us, yeah. And we had, it was a two-phase trial. If you go to the second phase,
that's the penalty.
That's the penalty phase, yeah. And it's a whole different set of issues, whole different type of experts. So that's why it can be very expensive and time-consuming.
Right. As Cindy's organization's motto and mission is, they walk in the shoes of the client, try to understand the mitigating circumstances. But before you even get to that point, you have to look at it yourself and say, oh, this is a a gruesome crime, how do you come to grips with understanding this same philosophy?
Well, you do have to walk in those shoes. For myself, it was a matter of reading the Supreme Court opinion that reversed his conviction and for ineffective assistance, and spending time going through the file and meeting with Mr. Wolf and talking with him about issues that we had seen in the file, and then looking at just basically the whole forensic case and the not eyewitnesses, but witnesses who had seen Mr. Wolf at various points in time.
Right.
When you put all that together, we really felt that this was an innocence case that we were dealing with. And at that point, it was like, okay, we need to give this our best effort. And quite frankly, as a firm, we spared no expense in putting a team together and preparing a defense for Danny. And I know from a time standpoint, myself, Craig Proctor, and Cindy put thousands of hours of our time into preparing it.
And what was the end result?
End result, unfortunately, the jury found Mr. Wolf guilty of the 2 murders, but because of the work we did on the mitigation side, the jury found that life without parole was the appropriate penalty and not the death penalty.
Do you still feel that it was an innocence?
Yeah, I very much feel it's still an innocence case.
Has that been appealed?
Is currently being appealed right now. We had some issues with the transcript not being transcribed in a timely manner. Those are issues up on appeal, but the whole totality of the case is up on appeal. It was argued before the Missouri Court of Appeals in September of 2009, 2009, and we still await an opinion.
And we're hopeful.
Yeah.
Yeah. How do you describe Danny Wolf's story with all the mitigating circumstances?
Well, Danny Wolf is an older client, and he may not appreciate me saying it that way, but he had some age on him.
Yeah.
And so he had, going back and looking at his life, he had a lot of the same kinds of problems we had talked about earlier.
Right.
He'd been very early on in a boys' home, for example, and really had experienced institutions at various times in his life, starting at the tender age of 9. But I think one of the things that really moved both the jury and us was the ways in which the kind of human being he had chosen to be when he was on death row. He was, I think, kind and compassionate and helpful. He educated himself. And it was really, I think, for the jury, probably as important the relationships he had built in prison and the kind of person he had become in prison despite its horrors, I hope, in large part, inspired the life verdict.
Mm-hmm. This obviously changed your outlook to the law, didn't it?
No question. No
and
question.
You're still actively involved in the case, right?
We are still actively involved. We did not write the appellate brief. We worked with another firm who provided their services pro bono in preparing the appellate brief. But we are still actively involved in it. And if we get a favorable outcome from the Court of Appeals, myself and the firm and with Cindy are prepared to retry the case again.
It's tough going up against the establishment, isn't it? Especially when someone's been convicted, right? Because the facts are already there. It's hard to dredge up original information that hasn't been gone over already, isn't it?
That's hard, and I think the other thing is the human nature that we really faced is its jurors do not feel comfortable disrupting the decisions of a former jury.
You find that to be true?
Yeah, that's been and I think one of the biggest obstacles we had was the inability to really have any meaningful conversations with the jurors about the fact that Danny had been convicted before and how that would affect their decision making. So in essence, there was a 13th juror sitting in that room, and that was the former jury. Right. And so it weighed against us.
How would you have meaningful conversations with the jurors?
About that?
Yeah.
Well, that's what we would use Brett for.
Yeah.
But the judge wouldn't let us talk to them about it. We would have liked to have helped them understand that this was a new ball game, that they were going to be hearing things the other jury didn't hear.
Right.
Our trial was much longer.
Yeah. I mean, the first trial was, 7 days, I think, from picking the jury to a decision that the death penalty should be imposed. Our trial was 4 weeks.
Yeah.
So substantially longer. I think the critical thing would have been to educate the jury not only that there was a prior trial and that we're kind of redoing the case, but why we're back here. In other words, the ineffective assistance of counsel in the first trial provides testimony. There's testimony. There's things that were done in the first trial that were not done correctly, at least in our opinion, and that's the challenge.
Well, I want to thank you very much for spending time with us on it, and again, congratulations on your case and your award.
Thank you very much.
Cindy, congratulations again on this Danny Wolf case and many other cases. And I guess probably the best thing in closing the show is to make kind of a, an opening where you might want to say to all lawyers out there who are faced with these death penalty cases, how they can come to you and how your organization can help them.
Well, they can contact us either by phone or through the website, and we can help them because we bring 16 years of capital trial experience to the table, and we have a very diverse group who is very experienced in the field, and both the investigation and the presentation of life history information.
Well, I want to thank you again for sharing your time with us, and I'm sure a lot of people are going to be contacting you with unfortunate cases, but you can help them out.
Yes.
Thank you.
Thank you.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.